Good morning, and welcome everyone. Thank you for joining us again this morning for our Google Hangout session. My name is Lior Samfiru, and I'm here with Lumi Punja.
Good morning.
We're always happy and excited to be back here and talking about employment law, workplace rights, and answering questions. And we pick topics usually that come up in our practice, things that people ask us about, things that we see, things that we feel are important for those watching and listening to know about. Now, we did a session a couple months back about misconceptions when it comes to losing your job, termination of employment, and employment law generally. We got a great response, and we decided to continue that. So what we're going to do today, we're going to talk about some additional misconceptions, things that people believe to be true when they're in fact not true. And this is very, very important, because if you believe certain things to be true when they're not true, that may impact your decision-making, that may impact how you enforce your rights, that may allow someone to get away with providing you less than what you're owed, and that's wrong. And a lot of what we do is trying to debunk myths and to clarify misconceptions. People call us all the time saying, well, I know for a fact that this is true. Well, no, wait a second, that's actually not true. That's completely wrong. So we're going to go today through a list of things that people come and tell us all the time, and they assume for a fact to be true, but in fact they're misconceptions, they're false, and we're going to not just tell you what those misconceptions are, we'll clarify the truth, we'll tell you how things really are, and hopefully give you an army with some information today that you can use in your everyday life, in your relationships between you and your employer. And by all means, contact us with any questions. If something is unclear, if you want to know something more specific about your situation, you can always contact myself or Lumi. Happy to talk, happy to answer any questions. And we certainly would love your feedback on this session to help us make future ones even better. Now, with all that said, I'm going to turn it over to Lumi, and we'll start listing off some misconceptions and tell you what they are and what the real truth is.
Yes, and I will start with an item, a misconception that is out there in the context of employers trying to reduce risk. They try to reduce risk. They try to I guess, temper somebody's expectation when they hire them, and for that purpose, to that end, they opt for a fixed-term contract, thinking that they can avoid the obligation to provide someone with termination entitlements if the term of the employment is fixed, 6 months, 1 year, 2 years. Again, it's a risk. It's a measure meant to reduce risk, but it backfires. It can backfire big time if the contract is not drafted properly. Because if there is no termination clause or exit clause in that contract, the employer if the employer ends the contract prematurely because the employee was unsuited, not fit for the job, the employer may be on the hook, may be responsible for the balance of the contract. So if you start with a 1-year contract and you end it prematurely, 6 months in, the employer may be responsible for paying the person 6 months of wages, and that person is not doing the work. And so it's very risky to use, well, it's not advisable at all, not cautious at all, to use fixed-term contracts that are not properly drafted, that are not put in place by lawyers. And as lawyers, in fact, as employment lawyers, we tend to stay away from fixed-term contracts. We tend to recommend to our clients to stay away from them, just because they can bring so much risk. Again, some employers are under the impression that they can simply renew a fixed-term contract multiple times, sometimes 10, 15, 18 years, and the contract remains fixed term. That's not the case. A fixed term contract that gets renewed multiple times transforms into an indefinite term contract, and the employee may be entitled to reasonable notice at common law. And so on the employer side, make sure that the contracts that you use are drafted by employment lawyers. And on the employee side, if you find yourself terminated in the middle of a fixed term contract, do not hesitate to call us for legal advice. You may be owed more than what you assume you are owed.
And I have a quick story. A few years ago, I was contacted by an individual that had signed a 3-year contract, 3-year employment agreement, and he was let go about 4 months into that 3-year agreement, and there was no early exit clause. So I told him, you're owed another 2 years and 8 months pay. By the way, his employer said that he's owed nothing. So I contacted the employer, and I was first accused of not knowing what I'm talking about when I told them they owe more money. As soon as they got some legal advice and they realized, oh my gosh, we owe this guy another 2 years and 8 months, they said, come back to work. And he was very happy to resume his employment, and he came back to work. The lesson, of course, is with the fixed term contract, it is probably something an employer should avoid. For an employee, remember the general rule: if you sign the fixed term contract and you let go before the end of the date, you should be paid the balance of the contract. Now, moving on to a different misconception, and this is one that we certainly see coming up all the time, and this is the belief that just because there's an employee is guilty of poor performance, that means they can be let go without compensation, without severance, and that's wrong, absolutely false. So let's break this down. For an employer to let an employee go without compensation, without severance, the employee would have to be guilty of very significant misconduct, usually misconduct that's repeated, and usually only in situations where the company has done whatever they can to rectify that misconduct, but they fail. It is very difficult to do that. That's what we call cause for termination. And in most cases, if you're guilty, I say that in quotation marks, of bad performance, you don't reach that level. Now, I'm not saying that an employee should be a bad performer. Of course, all employees should do a good job. But just because you may have not performed to the standards, that does not mean at all that you can be let go without severance. Now, you may be able to be let go, but with full compensation, full severance based on your age, your position, and the length of your employment. So let me give you an example. So let's say you just had a bad performance review, you didn't have a good year, you didn't meet your targets, and your employer is saying, well, this can't continue. Fair enough. But does that now mean the employer can let you go without compensation? Well, the answer is no, unless, of course, this has been going on for a while. They've provided you several performance reviews. They've tried to provide you help. They've warned you, here's what's going to happen if you don't improve. And everyone else has been able to do it and you can't, and there's clearly the problem with you. At some point, maybe the employer can reach the point of cause, but let me say that it's extremely difficult, almost impossible in some situations, to let an employee go for cause because of bad performance, as opposed to, of course, you can let someone go for cause if they were stealing or if they were harassing or someone or using violence. Of course, bad performance rarely rises to the level. And it is as difficult that it is to terminate someone for cause for bad performance, it's even more difficult to terminate someone for bad performance if they've already worked for a period of time, if they have longer service. The more service you have, the more difficult it is to terminate employment for cause. And in our practice, what we see so many times is employers pulling the trigger on a termination for cause because of performance way before they should. And from the employee's perspective, the employee may think, well, yes, I didn't do a good job, so it makes sense that the employer can let me go for cause. Well, no, you cannot. That cannot happen in most cases. And not only can it not happen, there's not even a discount. The employer doesn't get to say, well, you weren't a bad performance, you weren't a good performer, so we're going to pay you severance, but we're going to pay you less. That doesn't work. You still get your full severance. So remember that bad performance does not equate to termination for cause.
Yeah, I would just say that, I would just add that we see in our practice employees coming to see us because, let's say, 20 years into their employment, all of a sudden they become bad performance, and their, I guess, evaluations start to be negative, and they're told that the job is on the line, and they're scared. They get scared. Like, again, they held this job for 20 years, all of a sudden, again, the job is on the line because of alleged poor performance. Sometimes poor performance is subjective, and sometimes it can be like the employer's concerns can be legitimate, but you don't become a bad performer after 20 years with the company. So employees shouldn't get intimidated in those circumstances. They should get legal advice, contact us, and we can go over entitlements and options in those cases. Next, I would like to address another misconception that, which is that employees on probation can be let go with minimal or no notice at all. And going back to the first thing I said, again, employers don't like risk, and for the purpose of reducing risk, they hire someone on probation. Again, the goal is to test someone to see how things work out, to assess the fit within the organization, and so they introduce a probation clause in the contract, and employers believe that if somebody has not been with the company for more than a few months, then they're not obligated to pay give any notice, or if the obligation is there, then the amounts would be very small. That is completely wrong. There are numerous cases, some of them very recent, where employees received or were awarded notice periods even longer than their actual service. So there's a case with a young manager with 2 months of service who was awarded 3 months of notice.
Right.
A tax accountant with I believe 1 month of service only received 3 months of notice because the job was difficult to replace. Again, these people were let go in the middle of their probation period, and in some cases, their suitability within the company, their fit within the company was not properly and assessed on a good faith basis, and because there was no properly drafted contract and termination clause in place, the employers were on the hook for significant damages. Again, a well-drafted probation clause, a well-drafted termination clause protect employers from expensive lawsuits, from expensive awards awarded against them. So by all means, take advantage of a well-drafted contract to limit your liability.
Moving on with another misconception, another situation that we see is the misconception being people believe that an employer can limit a person's termination entitlements after the employee has already started working. So no, that's not the case, not at all. The time, really the only time an employer can try to limit a person's future termination entitlements is at the time the employee is hired. That is done by way of an employment agreement. An employer can enter into an employment agreement with an employee that says, in the future, if we decide to let you go, we're going to pay you less severance or a certain amount of severance. Limit the person's entitlements. Now, that's a topic for a different discussion. As an employee, you should be very concerned about that. Something like that can cost you tens of thousands of dollars, potentially hundreds of thousands of dollars. But that aside, once you're already working, an employer generally cannot then say, well, now we understand. Now we heard Lumi and Lior speak on the Google Hangout. Now we want you to sign an employment agreement limiting your future severance. The reason for that, the reason that that can't happen is for you to be able to give away your future severance once you've already started working, you have to get something in return. So what happens when you start a job? When you start a job, you get the job, and in return, you give your consent to be bound by certain terms, including potentially a term limiting your severance. But once you're already working, if you give your consent to be bound by terms, you're not getting anything in return. So there's no bargain, there's no deal. For any contractual term, for any term like that to be enforceable, it has to be a give and a take. You have to give something and you have to get something. So if your employer comes to you and say, hi employee, we want you to sign this new employment agreement, just sign right here. You're already working for the company. In most cases, that agreement is not going to be worth the paper it's written on because you're not getting anything in return. Now, If the employer says, well, we want you to sign this new employment agreement, but we're going to give you something in return, maybe a signing bonus, maybe a pay raise, a promotion, and you in fact get one of those things, then at that point, yes, it is quite possible that agreement that you sign may be enforceable because you got something in return. The lesson here is very important. If your employer comes to you once you're already employed and asks you to sign an employment agreement, be scared, be very scared. That's never going to happen in order to provide you with better terms than what you had before. The only reason, and well, almost the only reason why an employer is going to ask you to sign an employment agreement once you're already employed is because that agreement provides for better terms for the employer, okay? And in most cases, that is a termination clause. So you may not understand, and you sign an agreement that says that if they let you go, you'll get a fraction of what you otherwise would have gotten. And a year later, you lose your job, and now you realize, wait a second, now I'm going to get 3 weeks pay instead of 8 months pay, for example. A very bad idea. In most cases, an employment agreement that's signed after the employee starts working is not going to be enforceable unless you get something in return. But beyond that, if you've been presented with an employment agreement to sign, have us look at it. Let us tell you what's there, because I promise you, it's not being done. It's not being given to you just as a standard thing. There's a reason behind it, and usually that reason would be to try to limit future severance. You have to be very mindful of that.
And the signing bonus may be very tempting. Let's say $1,000 coming your way out of the blue, but then when you weigh that against the benefits you're conceding as a result of signing that contract, the choice is obviously
$1,000 bonus, and you give up $50,000 in severance. Not a good bargain. So you're absolutely right, Lumi. That's something that you really have to pay attention to.
You have the option to turn down a signing bonus, for example, turn down a contract. So, and in order to make an informed decision, you definitely need legal advice. One more misconception that we would like to address today is the belief that smaller companies or not-for-profit organizations somehow have different diminished obligations towards their employees. That cannot be further from the truth. And whether we're dealing with a corner store or with a large corporation, multinational corporations, the obligations are the same, especially with respect to termination pay. And small businesses may underestimate the risk and their liability. For example, if they've had an employee for a very long time, a very loyal person, if for business reasons I guess the store, for example, has to let go their employee, their obligations, their obligations to provide termination pay are significant, huge. And so our clients are surprised, or people that call us when we tell them that, yes, even a small company with 1 or 2 employees potentially owes 2 years pay to a departing individual. They're shocked and they don't understand, and they're confused. And so again, don't assume that just because the company you're working for does not have the resources of a corporation, your rights somehow are diminished because of that. And so the rights and obligations don't change based on the size of the company or the nature of the business.
And the reason why that misconception exists, and I think it needs to say, is it's actually perpetuated by the Ministry of Labor. And then let's break this down a bit, just so people understand why that misconception exists, because you may finish listening to us and go online and read just that. Your minimum entitlements may depend whether you work for a small company or a large company. So people at large companies have different minimum entitlements than people with small companies. But the key operative word here is minimum. Your minimum entitlements. Your full entitlements, on the other hand, what we call common law entitlements, are the exact same whether you work for a company with 2 employees or 2,000 employees. So when you read online that only a company with a $2.5 million payroll is required to pay severance, That's true for minimum entitlements, but who cares? Forget about that. Your full entitlements and that company's full obligations are exactly the same as any other company. So the bottom line is, when it comes to total compensation and severance, it's going to be the same big company or small company. And those entitlements are based on usually on age, position, and length of employment, not the size of the company or the size of the company's payroll. So with all of that in mind, I really think this bears repeating. The Ministry of Labor advises you with respect to your minimum entitlements, okay? And unfortunately, they don't tell you that that's all they're doing, but that is all they're doing, not your full entitlements. That's why we see every day people that accepted far less severance that they were owed, far less, to the tune of tens of thousands of dollars, because they may have gone on the Ministry of Labor page and got the incorrect advice. They realize, oh, the employer, it's a small company, they don't have to pay severance, so they offered me 2 weeks pay, I should be happy with that. When in fact, they do have to pay severance, and that employee could have been owed 6 months pay. Don't let that happen to you. Don't let that happen to someone that you know, and don't fall for that misconception. That is a huge, huge misconception. Not a day goes by that we don't have someone calling us that's under that misapprehension, and I think we need to spread the word to everyone that that's just not the case.
And I would also add that smaller companies are potentially in even greater need for a properly drafted contract to reduce their liability, simply because of the limited resources, maybe. And so, again, just because you're a small business, don't assume that you don't have to you don't need employment contracts that are properly drafted with clauses in place that protect you from liability.
Yeah, and oftentimes employers we speak to are very upset to find out that they have all these obligations. You know, we can't afford it. I understand that. That's the law, and you, the employer, would have had the opportunity to limit your entitlements with an employment agreement. If you chose not to do that, well, there's nothing that can be done. You have to pay what you have to pay. The time to deal with limiting entitlements, if you're the employer, is at the beginning of the employment relationship, not when it's time to let the employee go. Now, moving on, we had a couple here. I'm going to combine them into one just because we're getting short on time. And that is certain misconceptions dealing with leaves of absence from work. So the first one I'll say is, want to make clear, is that an employer cannot give notice of termination to an employee that's not at work, whether you're on a medical leave, whether you're on a parental leave, a pregnancy leave. If you're not at work, your employer cannot give you notice of termination. By that, I mean that if they do give you notice, that notice doesn't count. So here's an example. We've seen this happen many times. An employee is on a medical leave of absence, let's say, and the employer shuts down the department and they have to let everyone go. So it's a legitimate termination. And the employer says to the employee on a leave, okay, we're telling you that your employment ends in 6 months. In the meantime, this employee is not going to be at work because they're on medical leave. And the employer says, well, that 6 months notice that we gave you counts. No, it does not count. You cannot give notice to an employee that's not at work. It just doesn't work that way. Notice implies that the employee is working, earning compensation from the employer. The notice would only start running at the end of that period when the employee comes back to work. So whether you're on a medical leave, a parental leave, you cannot be given notice of termination or effective notice. And that means that if the employer terminates, that would be without notice, and then you have to get pay in lieu of notice, severance, etc. Very important to understand that, and employers and employees get this wrong all the time. Another misconception is that while you're on a leave of absence, on a medical leave of absence, the employer has to continue benefits. No, that is not true. When you're on a medical leave of absence, the employer does not have to continue your benefits, unless, of course, there's a contract of employment, an agreement signed that says that they would. The law says that the employer doesn't have to, just like an employer doesn't have to pay an employee if you're on a disability leave. You may have an insurance company paying you, but not the employer. The employer doesn't have to continue benefits. The exception to that, and this is where it gets a bit interesting, is if the employer does choose to continue those benefits. So the employer doesn't have to continue benefits when you're on a disability leave, but the employer says, we're going to do it anyway. So the employer chooses to continue benefits, and then at some point says, you know what, it's been too long now, we're going to cut off the benefits. Well, not so fast. Once the employer chooses to continue benefits for someone on a medical leave of absence, they can't just cut it off. Once you continue the benefits for an employee on a leave, that now becomes a term of employment. And you can't just change the term of employment. If the employer then decides to cut off the employee's benefits when they're on leave, at that point, that could be considered a constructive dismissal, which could be considered a termination and requiring the employer to pay severance. So even though the employer does not have to pay or to continue benefits when you're on a medical leave, once they do that, they can't just change it. Lumi actually has done several cases over the last year alone where the employer has done just that, cut off benefits for the employee on a medical leave of absence once they were continued, and that was a constructive dismissal, and we negotiated severance. So be mindful of that. Last point also as relates to benefits, we need to clarify is that when it comes to pregnancy or parental leave, while an employer doesn't have to pay the employee while they're on leave, they do have to continue benefits. So unlike a medical leave of absence where an employer does not have the legal obligation to continue benefits, our courts, our human rights tribunals have decided that for an employee on a parental leave, a pregnancy leave, an employer does have to continue those benefits. If they were to refuse to do that, that would be a breach of the Employment Standards Act. That would be a breach of the Human Rights Code. In other words, it would be illegal. So difference there between medical leave and parental leave. And if you're in that situation, if your employer has cut off your benefits, whether they've had it going when you're on a medical leave, or maybe they've refused to allow you to have benefits when you're on a parental leave, give us a call. Oftentimes we can resolve those matters very quickly. And again, don't fall for the misconception and believe things that are not true. Now, anything you want to add before you wrap up?
No, not at this point, no.
So thank you very much. These are some thoughts we had today, and again, we'd love to get your feedback as to what you think is interesting and what you would like to hear about in future sessions. We always try to pick things, topics that people hopefully will find interesting and things that we see come up, not obscure things. Now, a couple addresses I'll leave you with. If you lost your job, if you're worried about losing your job, or maybe you're just curious to know what you'd be owed in case you did lose your job, go to the severance calculator, severancepaycalculator.com. Find out how much you're owed. It's free, it's easy, it's anonymous, takes a few seconds. It's a great tool, and tell others about it. And of course, if you want to contact us, if you have any questions, go to our website. It's stlawyers.ca. stlawyers.ca. Happy to talk, happy to answer questions. And at the very least, hopefully we'll see you back here in a couple of weeks.
See you
Thank you
later. Bye.